there people on the internet discussing whether or not it's a problem that Trump ought to be assuming the defense of all 18 other lawyers, his own counsel in these cases, who have gotten indicted. And while I, again, initially think, yeah, he should, there's a party that says, like, how can you fund the defense of someone who either might have totally adverse interests to you, who might turn on you? Would they not then say that if he funds their legal defenses of the other attorneys who are indicted, that he's buying their loyalty, that it's somehow corruption, bastardizing the process? Is there any realm of the universe in which Trump could assume the defense of the other 18 indicted counsel without it being strategically impossible, potentially incriminating, or, I don't know, counterproductive if they decide to flip on him?
I mean, it's better off if you're paying for everybody's defense lawyer because you have better influence over the circumstance and situation, and you can make sure they have certain aligned counsel. And it doesn't violate any rules for that to occur. You have to be careful about disclosing the sourcing of payments and making sure everybody knows you're independent as legal counsel and so forth. But generally, that's a pretty common thing in these kind of cases, that there's a single source of payment for everybody, because you don't want somebody making up stories just because they can't afford a lawyer. Now, I think as a practical reality, Trump won't be funding everybody else's. Now, what's also true here is this prosecutor would indisputably call that an additional obstructive act in aid of the conspiracy, because this prosecutor is nuts. I mean, just pure batshit insane. I mean, this is, if the way I put it is that if the first case against Trump was Caesar crossing the Rubicon, the Georgia case is Caligula crossing the Rubicon. That's the depth of the depravity and depredation of this case. I mean, first of all, RICO has no application here whatsoever. It's an utterly patently absurd prosecution. Second, what the prosecutor is claiming is now a crime. Tweets are now a crime. Texts are now a crime. Setting up a phone call is now a crime. Sending messages is now a crime. Sending letters is now a crime. Asking people to watch the news is now a crime.
Robert, but
and not only that, providing legal advice is now a crime. Asking for legal advice is now a crime. And giving legal advice is now a crime.
Well, Robert, let me steelman it for you. I'll pull a legal eagle here. None of that's a crime, Robert, unless you do all of that in furtherance of a crime, and that's the bastardization of 2 + 2 = 5. They weren't giving legal advice, Robert. They were aiding and abetting in committing a crime. Trump wasn't.
But the aiding and abetting was the illegal advice. Was the meeting? Was the text? Was the giving people? This is, people can go out there and look. Well, you can have innocent acts in furtherance of a conspiracy. You will find no example where the only act in furtherance of the conspiracy is itself entirely legal, right? There usually will be mixtures, right? There'll be this act, like, let's say I created an entity to hide money, right? So the creation of the entity is a legal act, an act in furtherance of a conspiracy, but it was used to hide money, right? What's unique here is that she's saying these acts are in furtherance of a conspiracy without any additional act as criminal. She's just saying the thought. Oh, you thought something and you weren't allowed to think that. That's all fraud. That's all mail fraud, wire fraud, RICO fraud, racketeering, enterprise, all that ridiculousness. Solicitation for someone to violate their oath. For example, she actually calls it a crime that Mark Meadows asked to see the signature match check. She says that itself, by itself, is a separate solicitation criminal act.
Robert,
this has never been charged in the history of America. There's no analogous case in the history of the country.
Let's just bring this one up. I mean, I think did we talk about it last week? I'm not sure. On or about the 70th day of 2021, whatever. John Trump, yada yada yada. He
committed a felony crime by just asking. Yeah, go ahead.
To engage in conduct constituting the felony offense of violation of oath by public officer by unlawfully, quote, decertifying the election or whatever the correct legal remedy is.
Exactly. He literally asked whatever the correct legal remedy is, that is now a crime. That's why I say there's nothing like this. I mean, it's unheard of. It's unprecedented. It's unparalleled. There's nothing. It's not just that it's interfering in the election. It's not just that it's going after attorney-client relationships. It's not just that it's going after federal employees for doing their job. It's not just because it's going after the leading presidential opponent of the existing administration or that's going after a former president. It's that it's claiming things are crimes that have never been crimes in the history of America. And that's why it's so dangerous. It is by far the most dangerous indictment brought for constitutional rights. I mean, New York was bad. The Florida case was worse. The January 6th D.C. case was even worse. And this case is the craziest by far. But to take it back, I mean, there's legal defenses, constitutional defenses, procedural defenses, a whole bunch of things available. But I think it's useful to remind people what apparently Elon Musk's community notes folks at Twitter don't know, what a lot of Republicans don't know, what almost every Democrat doesn't know, which is what the Trump election contest actually presented. And if you read the indictment, you might not know that election contest even existed. Like most Democrats, like many Republicans, like many in the media. And the reason why I'm not in that indictment, the reason why Cleta Mitchell's not in that indictment, the reason why Patrick Witt is not in that indictment, the reason why some others are not in that indictment is because they don't want the world to know about the election contest. So for those that don't know, Trump only brought one election contest anywhere. People say, oh, there's 60 suits that were addressed by the court. None of those were Trump's election contests. Trump only brought one, and he brought it in Georgia. Number two, that election contest was never heard. So like community notes got confused with other cases brought by other parties, not by Trump in Georgia. So the Lynn Wood case was just Lynn Wood. The Sidney Powell case was just Sidney Powell. Other electors brought other electors' challenges. Trump only brought one election contest in Georgia himself.
Let me stop you just so that people don't accuse me of not asking the question everyone's asking. What were the other 60 lawsuits? The talking point is Trump and team brought over 60 lawsuits. All of them were dismissed. How many of them got to the merits? But what were the other 59 some odd lawsuits?
They're different kinds at different times in different places. So some were pre-election, some were during the election, some were after the election. So it depends on the circumstances. But in all the other cases, it was either electors or local individuals bringing suit, not Trump bringing suit. And so Trump was rarely a party to any of those claims, and those were usually limited procedural claims. There was only two major cases that Trump supported: the election contest in Georgia, and he supported the U.S. Supreme Court case that was brought with all the attorney generals and members of Congress. Those are the only cases that really mattered. The rest were ancillary efforts by ancillary parties to get to the issue. Many of them brought by Sidney Powell, which got nowhere, unsurprisingly. Some brought by others that were aligned in that sector, Lynn Wood, etc. What is true is that the Kraken got nowhere. But what is not true is that Trump's allegations got nowhere. What happened in Georgia law is that when you file an election contest, court has to be assigned, the right court has to be assigned, and within 5 days, set a hearing, and in 10 days, hold that hearing from the moment it's filed. Georgia never did. Georgia didn't schedule it until after January 6th. It was moot by after January 6th, so it was dismissed at that point. That's what happened. And Trump appealed to the Georgia Supreme Court saying, look, Fulton County Superior Court won't do their job under the law. And the Georgia Supreme Court dodged it by saying, well, see if the Court of Appeals would do something first. And the Court of Appeals never did. So, I mean, they just played a game, and they only got away with it because the Court of Public Opinion was distracted by the Kraken and Dominion and all of that red herring stuff. But let's go to what they detailed. The allegations in that complaint, none of which are meaningfully contested in the indictment. Yet they pretend that Trump had no basis for his claims about Georgia. Include, were there only constitutionally qualified people who voted? Were there only constitutionally qualified ballots that were cast correctly? And were the ballots counted and canvassed in a constitutionally qualified manner? For a presidential election, that's what rules the state legislature sets for who can vote in the presidential election, how they can vote in the presidential election, and then how those ballots are canvassed and counted in a presidential election. What we proved beyond, and so I was there during the early stages of the case. 90% of what's in that election contest came from work that I did, along with Patrick Witt and Cleta Mitchell and a bunch of great others. And in that, so I know it very, very well, over 400 pages of sworn affidavits and testimony in support of that electoral contest. It was backed up by detailed data, documents, and review and study. Anybody who tells you the 2020 election was on the up and up in Georgia has never read that election contest. Or they're liars. They're like Mike Pence. They're like Judge Michael Luttig. Frauds. I'll get into Luttig here in a little bit. But the details in there, who were the constitutionally unqualified people to vote? Well, to be constitutionally qualified to vote in Georgia, you needed to be 18 years of age at the time of the election. You needed to be registered at your habitation. It's important. Registered. You need to vote in the same place that you are registered. You need to have not voted or be a resident of any other state. And you need to not be dead. That's it. Unfortunately for the state of Georgia, they couldn't manage that. There were thousands and thousands of people who either were not 18 when they voted, were dead. Over 10,000 were dead when they voted. I mean, again, we had the obituary, not only the sworn testimony, the obituary of the person who died 3 days, 5 days, a week, 2 weeks before their ballot was sent in. I mean, this was irrefutable evidence. This is why they would never hear it. For all the people out there say, oh, the Secretary of State looked at it and the governor looked at it and the Georgia Bureau of Investigation looked at it and they all said it was fine. Well, if it was all fine, then why were they all so scared to allow that case to go to a trial and a hearing? If it was all so fine, why were they scared to do what they promised to do, which was publish the ballots? If it was all so fine, why were they scared to allow anybody as a third-party observer or a party observer to see the signatures actually matched? Instead, Mark Meadows, for merely requesting that, is now indicted as a criminal, as a felon, as a racketeer, as if he's a mobster. So there are people that were dead who voted. There are people who were under 18 who voted. There are people who voted in other states. There are people who voted who weren't registered within the same county. And my favorite, there are people who said they lived inside of a little post office box who voted, which is illegal in Georgia. You couldn't vote in the presidential election unless that was your home, and you can't live inside a post office box.
Robert, in fairness, I could probably live inside a P.O. box. Now, but the question is this. Where is this evidence for anybody who wants to see it, and why did a judge or, I don't know, someone in the system of justice never see it?
Oh, it's solely because the Fulton County Superior Court refused to assign a hearing to it against the law. And the Georgia Court of Appeals and Georgia Supreme Court refused to enforce that law. That was it. And I mean, that's all that happened. And then they just ignored it. And they got away with it in the court of public. They got away with it because the court of public opinion was not paying enough attention to that case, because they were all distracted by the red herring of Sidney Powell and the Kraken and Dominion and German servers and Iranian ballots and Chinese paper ballots and Venezuelan software and all that garbage. That's why that red herring was there. It was to make sure you didn't pay attention to that election contest. But in further details, now, the same evidentiary issues were raised before the U.S. Supreme Court, too. And the U.S. Supreme Court, again, played Pontius Pilate, did what they're really good at, which is running, hiding, and cowering like cowards under their desk, and didn't take the case. So that's the only reason we're really here at all. If they would have taken the case, even if they would have ruled against Trump, people would have been okay, much better, more okay than what happened. But that's only the first category of constitutionally unqualified aspect of the Georgia election. Second aspect is how the ballots were cast. So in order for you to be able to send in a ballot to vote in the presidential election by mail, your signature had to match. And in the way in which that was done, we'll get into the counting and canvassing, but that had to do. But the signatures didn't match. They didn't match in enough signatures that there was way outside the margin of victory. But that's only the second problem. Third problem is what's called canvassing, which is different than counting. Canvassing happens before the counting. So if somebody comes in with a ballot, and it's a mail-in ballot, it's a ballot application. First, you make sure that person's qualified to vote. Second, you match the signature against their voter registration card on the file. And when you match it, you have a party observers allowed to be there to make sure you're right, or they can dispute it before you open up the envelope and put the ballot in the ballot chain. And then later with the counting of the ballots, party observers also have to be present to make sure the counting of the ballots is done correctly.
Let me just stop you and ask you the obvious question. I mean, we're like now, what year is it? 2023. We're near 3 years later. How is any of this supposed to happen at the scale at which it was happening in 2020? This is a process that takes time.
Oh, normally, I mean, we spent extraordinary. I mean, people like Patrick Witt, a bunch of others who volunteered their time, took time off from the White House to work this, 18-hour, 20-hour days for weeks on end to gather this evidence, because there was so many claims coming from so many places. So you had to separate out the wheat from the chaff. But let's go to the counting. So first of all, Fulton County decided that they weren't going to count them at their precincts, which was problem number one. I mean, that's where the Republican Party in Georgia, Ronna McDaniel, Romney, her typical nature, she was asleep at the wheel. They had control. Contrary to what like Pedro Gonzalez, when he's not busy hating on Jews and figuring out new race war strategies, is currently saying about how, why didn't Trump make sure that the money raised for the election contest went to the election contest? It's because Trump was never in control of that money. The Republican National Committee was. The Republican National Committee chose to not give it to the people who needed it.
Let me stop. I know you've had your choice words for Jenna Ellis, and I have had my choice.
They added her to the indictment.
So Jenna Ellis.
Jeff Clark is in there too.
Yeah, I said Jeff Clark. Mark Meadows we haven't had on, but Jenna Ellis. People were ragging on Jenna Ellis for being a hypocrite in that she was complaining about the crowdfunding for Trump's defense.
And now she's got
to do it for herself. And I said, look, I don't remember that's what she was complaining about. I brought up our highlight that I remember having posted.
She used to be complaining that the money wasn't spent the way it was supposed to be spent before she became a dissimp and all that, and before she made the dumb decision to cop a plea with Colorado, which is now going to hurt her in this case. That's what I think as well. Before she went and made those dumb decisions, her complaint was a legitimate one that I made from the very beginning, which was that the Republican National Committee was raising money for election contests that they weren't using for election contests. Okay. But that was not on Trump. Trump went in his own pocket for some of that. So that never should have happened because there was plenty of money for it. But on the counting, so they decide they're going to count all the ballots in Fulton County in one centralized location. That's a disaster because all of a sudden you lose chain of custody of the ballot. And this is the real problem with the machines, by the way. The fact the machines are hackable is always an issue, but that's a lower risk because that's easier to track and trace from an evidentiary perspective by voter disparities than a lot of these other ways of fraud is. The bigger problem is when you interfere with ballot, when you print a ballot, you can just keep printing ballots and you can keep printing replacement ballots. You no longer have clean ballot chain of custody. Like the ballot should be treated like a dollar bill. Right. So normally they would come in, they would be specifically serialized and numbered. You only had so many of them. You couldn't print new ones. You had just enough for enough people to vote. You couldn't just print constantly and just and then you can sub them out. Right. I mean, because then you have a rogue actor. Let's say they got 500 ballots here. They're going to deliver it from this location to this location. They take those, throw them out. They put in their 500. So that's why we always wanted the ballots printed. We wanted to see weird anomalies with any aspect of the ballot. Not only the physical form of it. And by the way, Ratburger promised to do that when he gave his big fat check to his buddies at Dominion in 2018. He said, don't worry, we're going to publish all the ballots for the world to see. He hasn't published even one yet. He's been dodging that for years. So, but why? If there's nothing to hide, why does Ratburger and Kemp and Georgia keep hiding everything critical? The signatures and the ballots. That's what the election was fine. The election just can't explain to me yet. They haven't been able to explain it for 3 years. But that wasn't all. So they have a centralized location. This is when the magic water pipe broke. The joke by Zero Hedge is that the indictment leaked from a water pipe in Atlanta to remind people that what was supposed to happen is during the counting of the ballots, somebody's supposed to be there to make sure nothing's going on that's wrong. All of a sudden, Fulton County told all the party observers, go home. Oh, well, we got to stop. We got a water leak. We'll start back up in the morning. And as soon as within an hour of the party observers being gone, that's when they grabbed those big buckets out. As Steven Crowder, they fact-checked Steven Crowder because they said, you defined the buckets in the wrong way. They weren't cardboard boxes.
They were Pelican. Robert, Pelican briefcases, I think, is the way we have to.
Yeah, I mean, there's those huge, massive, from underneath tables. What are they doing underneath the table to begin with?
They fact-checked it, Robert. They put them under the table because that's where they were going. They've been there the whole time. But Robert, it's obligatory now. because we keep going.
But wait, there's more.
It's
that there is. So people are gone. They don't see how the ballots. And I was getting contacted right away from people who are at the Fulton County facility who were enraged when they found out ballot counting. And for those that forget, also go back to the New York Times. Go back to these liberal publications. On election night, they were reporting the margin was there was too few available votes left in Georgia for Biden to come back. You can find Nate Cohn saying that. You can find a bunch of Democrats saying that. What happened was that, that 1% left to be reported just kept getting bigger and bigger and bigger and bigger. And that's when it was occurring, and that's where it was occurring. So when I was down there, one of the things we cross-checked to look at the data, not only got all the dead people voting, 2 young people voting, people out of state voting, people who moved voting, people in post office boxes voting, signatures that didn't match, canvass that didn't. There was no canvassing in the whole state, fundamentally, that complied with the requirement of meaningful signature match requests. And in much of the state, there was no counting of the ballots, egregiously in Fulton County, but also other counties, because it was the suburban counties where some of the worst abuses were taking place. And people like Jeff Clark at the Justice Department was like, we got to look at all these allegations. Isn't our job as the U.S. government to make sure that this election is on the up and up? And we ignore, because one of the things we did to get evidence up to the Justice Department and other places that Bill Barr hid and covered up, like he did the Michigan case of criminality that he deliberately covered up the criminality and the fraud with, and now wants Trump indicted so he never faces consequence himself if Trump wins election in 2024. And maybe Luttig. If Luttig thinks ex-Judge Luttig thinks these kind of theories are fine, well, maybe we can indict Luttig now under his own approved theories, because this guy's so dim he can't do that math even further. But what the additional component of what took place in Georgia in terms of the counting of the ballots is that they not only counted more than supposedly were even present, they counted them without the presence of party observers, and they counted them without it being properly canvassed in the first instance. So you had collectively hundreds of thousands of ballots. My estimate was close to 250,000 ballots could not be constitutionally counted. And that was about 20 times more than the margin of victory necessary for the election contest.
But Robert, if all things being equal, it would have impacted both parties equally. Why would it have benefited Biden and harmed Trump?
Oh, it doesn't matter. Under the election contest rules, all you have to show, like Jimmy Carter did in an early election to get him elected to the state legislature, like Barack Obama did to get himself into the state legislature in Illinois, both of them using signature match checks in different ways or other methods of election contest to get into power, is all you have to show is there's enough constitutionally questionable ballots than the margin of victory. You'd never have to prove which way they actually voted. And the reason for that should be obvious to everybody. It's why we have prophylactic rules about the counting and canvassing of ballots. If we incentivize somebody to do it in that way, then they say, well, yeah, I destroyed a bunch of ballots, but you can't prove which way they went. Then we won't deter that bad conduct. That's why these are strict enforcement rules. That's why it was such an obvious slam dunk winner that's why the media pretended the Georgia election contest didn't exist. That's why the state of Florida, the same Fulton County corrupt courthouse that's ruling over this indictment, pretended it didn't exist and didn't assign it properly. The Georgia Court of Appeals pretended it didn't exist. The Georgia Supreme Court pretended it didn't exist. The governor to this day is lying and pretending it doesn't exist. And they're even pretending it doesn't exist in the indictment. And that's just and on a factual basis, an honest trial, and in a Georgia state proceeding would be televised, an honest trial would prove that not only did every single defendant believe what they were doing was subjectively true, they believed in it. So they can't prove intentional fraud on just that aspect. That's what Dershowitz focused on. He said, if I was handling the case, I would hammer that issue because it's quite obvious that everybody, at least Trump, believed what they were doing, what they thought the election was stolen. But secondly, as an objective matter of truth, which is put at issue by this indictment, and they're putting every state, by the way, at issue. They're putting Pennsylvania at issue. They're putting Arizona at issue. Okay, let's have at it then. Let's show what happened in these elections so that if they got a full honest trial, only a completely prejudiced, bigoted jury could convict, because it would prove that, in fact, 2020 was stolen.
Robert, let me go back to the original question. Why weren't you included in the indictment? Was it because you didn't give that type of legal advice, or you think they don't want... First of all, whether or not you would revel in being indicted, I think you would not go silently into the night. Was it because you didn't give specific type of advice, or because you think that they don't even want to have you speaking out?
It's two different components. One is they want to stay away from the election contest because that makes them look like idiots and asses to the entire world. They don't want the world to know about the election contest, the factual, and that was my role as part of the proceeding. The second is kind of coincidental. I probably would have been around and in the room for some of these conversations, but for about midway through, the Republican, Mark Meadows had recommended me to the Republican National Committee to be retained. Cleta Mitchell had recommended me to be retained. Others close in the White House had brought me in the first place. They didn't trust the other lawyers. And in the other alternative was at the time, Sidney Powell, who then got linked up with Rudy Giuliani. And Rudy wanted his own people and all the rest, which was fine. But basically, the Republican National Committee went with Rudy and kind of Sidney for a brief period of time, and then Sidney was jettisoned. But the Republican National Committee didn't want me in from day one. And the lawyers close in the White House that were giving bad advice, close to the campaign, they were giving bad advice. I exposed them lying about Georgia for the first time I got down there. Now, Rudy Giuliani, I didn't know until later, actually took credit for that. He said he came up with the idea. But so it was and I realized where they were going. I knew Dominion was a red herring from day one because of how the Georgia officials were acting about it. So I was not going to hang around for that. I knew it was going to be a shit show, and I was like, I'm out of here. And so coincidentally, because I was like, it would be easy for ego reasons or money reasons to hang around. I wasn't going to hang around something that I thought was going to be counterproductive, which is what it became, counterproductive, sadly, because nobody remembers the election contest. Everybody forgot about signatures matching, the glaring vulnerability of the entire stolen election. And they all ran away with, I was trying to explain to people that, the QAnon stuff was insane by that point, people in that community. People were saying we had to explain to people why it's a bad idea to be talking about a military coup.
Robert,
right? Remember?
The thing, not only do I remember, but anybody who doubts the accuracy or historical revisionist nature of what you're saying, everything we've done since 2020 is online now. You can't. We don't take it down, and everybody can see. You were calling out the QAnon as a red herring distraction from the beginning. The German servers, and taking flack for it at the time. I didn't know what QAnon was at the time. And
Linwood, Sidney Powell, people tell them, "Oh, you'll be apologizing, Barnes, when they prove it all."
When she releases
the
Kraken
comes out, and da da da. It was every great crime needs a great patsy, and Dominion was the great patsy.
Now, but Robert,
and again, for all those out there, I hate machines being involved in elections. I'm for paper ballots. I'm for voting only on election day. I'm for voter ID, just to be clear. But Richard Barris and I had researched this right away, and we knew it wasn't the machines because the vote deviation didn't correspond to the machines. In Georgia, now here's what we did figure out. A Democrat, by the way, sued. This is the other irony in this. A Democratic lieutenant governor's candidate sued after 2018, contesting the election. It's actually cited in Mark Meadows' motion to dismiss before the federal court on this indictment. And but apparently, Stacey Abrams was pretending she was governor for like 3 years afterwards. And yet somehow, this is in Georgia is what makes this even more insane.
Robert, she never did anything in furtherance of the conspiracy. She just said it out loud. It was stolen.
Oh, yeah, she did. She tried to steal it because what we did is the lieutenant governor, Democratic candidate, exposed this. He also exposed, by the way, problem with Dominion machines. All this sworn testimony about problems with Dominion machines come from the Democratic Party suing, by the way, but in Georgia. But in terms of prior to all this, but if you go into look at it, the lieutenant governor claimed after 2018 that there are unusual undervotes for him, when in reality there was unusual overvotes for Stacey Abrams. For those that don't that means people who only showed up somehow to vote for Stacey Abrams and literally voted for no other office. Well, the same thing happened in 2020, where a bunch of people literally just showed up to vote for Joe Biden and magically didn't vote for any other office. They're like, we're not buying that was on the up and up. And my view was it was another indirect method of proof. I said, let's take a look, and credit to Patrick Witt because he spent the hours and hours doing all the data deep dive. and his data team and some other. And Richard Barris was helping out behind the scenes and other people too. And I said, take a look if the precinct overvotes magically matches where Stacey Abrams got so many overvotes. And voila, yes, it did. And it was I'll give you an example. There were nursing homes in the same neighborhood where one of them had 95% turnout, which, by the way, is always unheard of, and the other one had normal 60, 65% turnout. In the same neighborhood, you'd have apartment complexes with the same demographics, whether it's age, race, economics, whatever, within the same area, and one of them has 85% turnout, one of them has 50% turnout. Why those locations? Because they're centralized places where somebody could take a bunch of other people's ballots and cast it for them. Most of 2000 Mules comes from video footage from Georgia. So that's not a coincidence. That was another method by which they did the illegal actions, by which they stole votes in Georgia. That's why it's so insane. This is like the gaslighting indictment of gaslighting indictments. It's now a crime to point out their crimes.
And I was going to say, as a joke, could you have foreseen this indictment back in the day that they would go after the lawyers? But back in the day, and
I was not for the elector challenge. I thought those strategies, one, wouldn't work. Two, wouldn't be persuasive in the court of public opinion. I wouldn't have recommended Trump get on the phone with Ratberger.
Stop. Can you remind everyone about that meeting? That was a meeting among counsel.
It's a settlement conference, which should remain secret. It's illegal that it's ever been publicly disclosed. Trump was fine on the call. It was just, you have to know these are scumbags who are looking to ambush him. And keep it focused on, Trump for about 24 hours was completely on board. He was like, yeah, let's just focus on signature matches. I was like, look, rally to one issue. You need the cleanest issue. You need the neatest issue. You need the most visual issue. And you need the issue you're going to win on, because otherwise you're going to get distracted by so many things. Nobody's going to know they can't get the story straight between day one and day two.
But hold on. It was a settlement conference among counsel that was surreptitiously recorded and then illegally leaked.
Exactly.
And
in violation of the confidentiality provisions. So which, by the way, was loosely part of the election contest filing that they're pretending didn't exist. So is where that settlement conference arose from. So I think there were tactical mistakes made, but absolutely no crimes. It's utterly absurd. Now let's talk about the procedural mechanisms whereby some of these defendants can get remedy.
All right. Well, hold on. Before we do that, just to cover your tushy here, for those who say that Barnes. I don't know. It wasn't critical back then. Even back then, Robert, we said, I'll say, you led me down this path. Giuliani's going to get sued for defamation for what he's saying. You said it, repeating stuff. Sidney Powell, Lynn Wood. So it wasn't a question of not foreseeing potential prosecution. I don't say persecution with these players.
None of them had ever done election contests. Even John Eastman, who I really like, I think he's a great constitutional law professor. He had never done an election contest. So the problem was the only people that were familiar with election law, other than me and my team, was otherwise either corrupt insiders working, like Trump's own so-called election lawyers in Georgia when I got down there, were also lawyers for Ratberger. I mean, this was a conflict that was that was a real conflict of interest. And that was true almost all across the country. And a lot of them were corporate law firm types that didn't want to get involved in this election contest anyway, if they didn't have conflicts. So then you have the outsider types. Rudy Giuliani, no history with election contests. Sidney Powell, no history with, she's a criminal lawyer, defense lawyer, criminal appeals lawyer mostly. Has zero experience in election contests. Mike Flynn, God bless him, national security, zero experience in election contests. Steve Bannon, God bless him, good strategist, zero experience in election contests. So they were out of their depth from day one. And that those of us that did have the experience were like, there's a path here. We know what the most likely successful path is, and we know what to stay away from. I understand. I mean, Trump thought Rudy was still the Rudy that took down the mob. So, I understand why that was the only lawyer he knew in the room. Every other lawyer was new to him relatively. But it was, but people can go back and look. Everything we predicted at the time came true, unfortunately.
Yeah, 1,000%. And I'd just say, like, it wasn't a question of not even being cynical enough or naive enough to think they wouldn't go after the lawyers. We were saying Giuliani's getting in trouble for what he's saying, because it's demonstrably false. Lynn Wood, Sidney Powell. Did you ever think they would
debate? I mean, it was a deep state operation. I mean, the people that were connected to that, QAnon, I think, was an algorithm developed by deep state to see whether they could create a fake movement in the country, and it worked tremendously. And Sidney Powell was approached, my understanding is, by, if the guy's Cuban and says he's connected to intelligence, don't take the call. Just FYI. And I knew about those people because they had approached me through the Flynn world a year before, trying to get to Alex Jones and trying to get to me. And I vetted them, and I was like, these people are all full of crap. It's a clear disinformation operation. And so, but, I mean, again, and if anybody has doubts about this, Time Magazine, they bragged about it a few weeks later, how they stole it. I mean, they called it fortification. I'd call it fornication. But it was either way the same. But there's plenty of legal remedies available for Trump and all the defendants in the crazy Georgia case.
Okay, so now do that now so that we can clip this and it will be a highlight. 1 hour, 53 minutes in, Robert. The legal remedies. Then we're going to get into Mark Meadows because he's got a separate legal defense. What are the legal remedies if it's not already clear to everyone else out there?
Sure. So, I mean, there's some that are unique to Trump. There's some that are unique to Trump, Meadows, and Jeffrey Clark. And there's some that are unique to the lawyers, and then there's the defenses that are in common. So for Trump, he can argue that the impeachment clause bars the indictment, both under the interpretation I previously argued, which is that that the president can't be indicted except by conviction in the Senate. And here, this was basically the exact. It's like the DC case. It's the same thing he's already been acquitted of in the Senate. And the interpretation is based on the plain language of the Constitution itself, which only refers to someone being able to be indicted, tried, or punished if they've been convicted. That's the specific. And by the way, at the time, other state constitutions said convicted or acquitted. So our founders chose to limit it to convicted. And now, there's other people that try to argue otherwise because it's never been adjudicated before. But here he has a unique argument because on top of that, here he was acquitted in the Senate.
Well, that's the question. Is the acquittal in the Senate, was it a quasi-criminal acquittal or a civil acquittal?
The reason why it was always considered to be equal to a criminal acquittal is because historically the Parliament in England could impose criminal punishments as part of impeachment. That's why that provision is there. It's saying that they were going to take away the power of criminal punishment from the Senate for impeachments and instead give it only to the separate executive branch. Excuse me.
Bless you.
But as part of that process, they limited it to only those convicted. And so so that's part one. Part two, so he's got two different impeachment clause grounds to dismiss. The second argument is the supremacy clause. Now, this applies to Trump, it applies to Meadows, it applies to Clark.
And Meadows is raising it now in a motion to dismiss filed, I don't know, Friday or Thursday, the supremacy clause. And I swear to you, it's not a joke. Whenever I see the word supremacy, I read into it white. So I'm reading the white supremacy clause, but I'm sorry. What is the supremacy clause, Robert? Although I know what it is, let everyone else know. And how can Trump raise it as Mark Meadows has already raised it?
What it says in the Constitution is that the Constitution is the supreme law of the land. From that, a state government cannot use its criminal or civil laws to either restrict or punish a federal employee doing their job under federal law. So this is how, in some cases, people like the man who shot Randy Weaver's wife, that's why he never went to trial. He asserted he was doing it within the course of his duties as an agent.
Randy Weaver was the Ruby Ridge, the sniper who killed a woman holding a baby in her arms in the house that set off the whole thing. Okay.
If someone is immune from murder charges because of the supremacy clause, how in the world could they not be immune from election-based charges? So the allegations against Trump all concern things he did while president, the allegations against Mark Meadows all concern things he did while chief of staff to the president. And all the claims against Jeffrey Clark concern the things he did as an assistant attorney general at the Department of Justice. As such, all you have to show is that there's any kind of nexus between what you're doing and the job. And here again, go back to my Covington kid suits. If tweeting about people you don't know in another state that doesn't concern public legislation is immune, like they said Elizabeth Warren and Deborah Haaland were for their libels about the Covington kids, how in the world is this not immunity not to be granted? So effectively, it's immunity under the Supremacy Clause. So that's grounds to dismiss, independent and separate from the impeachment clause, and available to both Trump and Jeffrey Clark and Mark Meadows. And Meadows, as you know, has already raised it.
Let me stop you there, just because I'm going to reshare Jeffrey Clark's Give, Send, Go in the link right now. Clark
is the guy that was the only conscientious actor in the entire Department of Justice during the elections, trying to do his duty and his job. And he wasn't trying to overturn it for Trump. He was trying to figure out what happened in the Justice Department, actually investigate whether crimes took place, like what their job is supposed to be. And for it, he's been blacklisted by corporate law firms. The D.C. bar is trying to disbar him. And now the Georgia prosecutor wants to put him in prison for 20 years.
Yeah, I'm just going to say, please share, donate if you can. Here is the link. Yeah, because we had Jeff on a while back. We'll blast this out as much. The only problem is, Robert, there's too many people who need help now because of this weaponized system.
But his case is a lot more compelling than Jenna Ellis's, let's put it that way.
True, and then
if you're going to support a Give, Send, Go, support Jeffrey Clark.
Well,
I'm not saying don't support Jenna Ellis for everybody out there, but I'm just saying that his claim it's much more constitutionally consequential. His actions were much more important and significant. The impact of his prosecution matters far more. Imagine if you can now be indicted for doing your job as a federal prosecutor.
Yeah, well, and Mark Meadows as well. It's not to hierarchize, whatever. It's not to make a hierarchy. There will be a hierarchy in terms of legal impact and importance, but they're all equally egregious on a constitutional front.
What Clark, Meadows, and Trump can also do is remove the case. Meadows already has. And by the way, what is somewhat misunderstood out there, that actually removes the entire case concerning all defendants.
So hold on, but he didn't move it yet. He got a hearing on the removal, right?
Technically, it's removed. And whether it stays removed is the hearing on August 28th.
Okay, so that's very interesting. So the hearing on the removal is heard by which court's jurisdiction?
So right now, the state court, they're supposed to all appear this week in Georgia. The problem with that is the state court no longer has jurisdiction over this case. Jurisdiction is now within the Northern District of Georgia at the federal court level. So the judge has scheduled what happens is when a federal judge gets this of federal removal because the allegation is there's either a federal defense or a federal employee has been alleged to commit an indictment concerning a federal offense, is that the whole case is removed, all charges, all defendants. And the first thing the judge can do is issue what's called summary remand. This judge, an Obama appointee, so I'm not overly optimistic about the outcome of the hearing, but even he admitted, this appears to be pretty obvious removal stuff. So I deny summary remand, and let's schedule a quick hearing where evidence can be presented. And he scheduled it for next Monday, August 28th, in Northern District of Georgia. Now, what the judge can do at that point is he can either remand it or he can remand part of it. He can sever it and say anybody that's not a federal employee is remanded back to Georgia. But if he determines that he's going to keep the removal for Meadows, that means he's going to keep it for Clark and keep it for Trump. And that means they're no longer subject to the Fulton County jury pool, and they're no longer subject to the Fulton County Superior Court, and they no longer have to depend on the Georgia Court of Appeals or Georgia Supreme Court. They now have the 11th Circuit Court of Appeals and the U.S. Supreme Court more directly. They have the U.S. Supreme Court even with a state case, but it's a little easier if it's through the federal system. So the notice of a honest judge who's not too political would recognize this should be removed.
But it's
an Obama appointee, so you got to put an asterisk there.
Okay. I look crazy here. I look at my hair, but Robert. It's a no-brainer for the removal. The only question is how many would it not apply to everybody?
He would probably sever the judge would probably sever, and he would have keep Trump, Meadows, and Clark, and remand the rest.
Okay.
Is most likely what the judge would do, but he doesn't have to do that. And then after that, even sort of at different times, you have motions to dismiss, and you also they should be bringing these motions in other cases. They haven't yet. Motions to stay. My view is to protect the First Amendment rights of press, assembly, speech, and petitioning the government, as well as protecting the integrity of the upcoming election. They should not have an indictment trial going forward during an election season. Stay every case until the public gets to vote on the verdict on election day. And if the cases are so compelling, you can pursue them afterwards. But at least then the federal and state judicial systems are not interfering with an election, conspiring effectively, being complicit effectively, and denying people their right to vote. But I, at a minimum, would bring those motions because it's something the U.S. Supreme Court could do that would stop all the cases and allow things to develop naturally through the election season and then deal with it afterwards. Well, it's the kind of remedy the Supreme Court might like, right? Okay, we can put a halt to this, but we don't have to make the ultimate decision. We can just limit the harm here so that the world isn't laughing at us about trying to lock up the leading opponent of the presidential campaign. But we don't have to get into the substantive merits because maybe the public helps simplify it for us.
Well, it might be too late for that, but also to allow the candidate to campaign freely without.
Correct. Exactly. Don't interfere in the election, and don't let the judicial system become complicit in interfering with an election.
Now, without getting into my tweet of yesterday, Robert. The idea that Trump would skip the debate on Wednesday, people are trying to fault him for it. Am I too black-pilled to say if he were to participate in that debate, he'd be accused of witness intimidation the day after?
No, it's always that risk. I mean, I think the reason why he's not doing it, two reasons. One, he's got a massive lead, but it's mainly to pay back Fox. That's the reason why he's doing an interview with Tucker Carlson on the same night. Right? It's purely payback to Rupert Murdoch. It's like, okay, Rupert, you decided to take shots at me the last 3 years. See how well your ratings are when I don't show up. And remember, he did this before January 2016. That he was like, Fox is not being nice. I'm going to skip a debate. And Fox panicked. Their ratings dropped, or their positive favorabilities dropped 30 points in a week. So Trump wants to remind them, and it's not a coincidence he's teaming up with Tucker, both to stick it to Fox. I think that's what that's about. But you're right. I mean, he was going to make a presentation on Monday about what happened in Georgia, and apparently his lawyers said don't do it. I think they're making a mistake. At least somebody should be doing it on Trump's behalf. Use the Georgia case to remind people, look at all the evidence. It was stolen. Don't get hoodwinked, bamboozled by the press.
But anybody who does it on Trump's behalf now, the deep state, the administrative
state,
they'll get arrested, indict you. So you can't even do that. Can we even talk about it here on Sunday night without getting indicted?
That's how insane it all is. Now that gets to, so you have procedural options of removal and stay. You have the motions to dismiss on the impeachment clause and supremacy clause grounds. But you also have motions to dismiss on First Amendment right of speech, First Amendment right to petition, First Amendment right of assembly, Fourth Amendment right of privacy, Fifth Amendment right of due process, First Amendment right against selective prosecution, First Amendment right against retaliatory prosecution, Sixth Amendment right to counsel. All of those are also implicated by the indictment in ways that are extraordinary. Now, Meadows has already brought motions to dismiss in the federal court on grounds of the supremacy clause and on grounds of the First Amendment. Freedom of speech and freedom of the petition. It could have been a little more robust, but they were filing it pretty quick and pretty early. But they're making, as Turley recognized, as Dershowitz recognized, as others recognized, they said almost the entire indictment. Dershowitz said under the theory here, he and Tribe and Al Gore could have all been indicted in 2000. So this is all speech. This is all assembly. This is all petitioning the government.
2000. He could be indicted now for his defense of Trump in his first impeachment. Indict him now.
It's only a matter of time where they try to go get Dersh. So it violates it violates the right to petition the government most specifically, right? I mean, when the indictment actually says Trump asked what the legal remedy was from the state official, and that's the crime, right? You couldn't have a clearer example. You can't call petitioning the government solicitation of violation of an oath, period. You can't call, and again, this goes all the way back 400 years. In the 1600s, they tried to allege seditious criminal libel against several people for their action of petitioning the parliament, and they said that could not be seditious libel, even if they lied, because that's petitioning the government, and that's completely protected. And our right is much more robust than the English one was. And it was critical to the Constitution. So and obviously when you're criminalizing speech like it does throughout the entire indictment, like tweets, like saying recommending press, like look at the statement that he made. And it was take out, it's worse than the DC indictment, where the Turley said, take out the speech and you have a haiku. You have nothing left in the Georgia indictment. You have almost no actions of any kind. It's almost all speech. When it's an action, it's petitioning or assembly. It's Mark Meadows setting up a meeting to speak. It's Mark Meadows conferencing with someone to speak. It's Mark Meadows asking to look at something, such as the transparency of the election, which is his right, like any American. The Fourth Amendment issues, because I'm sure they violated things in the grand jury process on right to privacy and attorney-client privilege. They couldn't have some of the communications they have without doing so. Fifth Amendment due process rights that are also implicated through the 14th Amendment that go back to the First Amendment, and that there's two kinds of selective prosecution here. It's retaliatory prosecution for his prior assertion of First Amendment rights. You couldn't have a cleaner case than is here. You asserted your right to petition, so we're going to try to put you in prison for it. You exposed our election fraud, so we're going to try to put you in prison for it. You gave legal advice to someone trying to seek legal remedy over a fraudulent election, so we're going to try to put you in prison for it. But also you have selective prosecution relating back to the case we talked about earlier, in that it's disparate. Here you had Hillary Clinton denying elections. Democrats have denied every single election they've ever lost. I mean, according to the indictment, John Adams was a criminal. Thomas Jefferson was a criminal. Alexander Hamilton was a criminal. Pretty much everybody in 1876 was a criminal. Both John Kennedy and Richard Nixon in 1960 were criminals. Al Gore and Alan Dershowitz were criminals in 2000. Jamie Raskin and every single Democrat in the House or the Senate that's been there has been a criminal in 2000, 2004, 2016, all three, where they denied Trump won the election. And that everybody, including the media that was advertising, asking electors to not vote for who they were obligated to. Is that not solicitation to violate your oath? Right? I mean, what's the difference? You couldn't have a cleaner case of being similarly situated and being treated differently with consequences to your First Amendment rights than the Georgia indictment. If this isn't selective prosecution, no case is selective prosecution. So there's two different levels there. That's a 14th and Fifth Amendment rights that are implicated through the First Amendment that enforce it, because it's selective prosecution because of its disparate treatment, and it's selective prosecution because it's retaliatory. And in my view, I would add a third component. I think the First Amendment should be interpreted to prohibit one administration indicting their opposing administration during an election. At a minimum, the remedy should be a stay. In my view, the remedy should be dismissal to discourage and deter such behavior. Otherwise, we don't have the First Amendment. The First Amendment is dead in America.
Snip and clip, people. 2 hours and 10 minutes in. Robert, let me read a few Rumble rants because they've been coming in. Hold on one second. Bring it back here. All right, here we go. And, okay, Robert David R. Okay, so we got here. Ignotum. With Robert L. Peters' revelations, will Hobbs bring the next distraction indictment for Trump? He'll need a fighter pilot jacket to go with his ace status. Robert, what's the...
That's Arizona. They're figuring that because Joe Biden went by the name
Robert L.
Peters, using a pseudonym to hide his conversations. It's another version of the Hillary email scandal.
Bless it.
He didn't want that information available to the public. He didn't want it subject to FOIA. He didn't want the Obama administration to know why he's using burner phones and anonymous emails. Which should be a reminder to everybody out there, there's utility to burner phones and anonymous emails and Signal accounts. When Joe Biden's using it, that Hunter Biden's using it, there's probably a reason why. It may be a useful tool to protect your privacy.
Yeah, but also maybe just don't text about how you're going to do it, because it defeats the purpose.
Of course. No doubt about that. And then Hobbs is a reference to whether the Arizona governor will tag on the indictments. Will Arizona jump in? Will Michigan jump in? The Wisconsin governor is demanding that his Department of Justice indict people. So they're all excited. Oh, look at this criminal power. We can just use it without any limits. And now, getting to the one last aspect of all of this, that corrupt hack, Judge Luttig. For those that don't know Luttig was a guy that a bunch of the Federalist Society types on the right wanted to put on the U.S. Supreme Court. And what he was basically a sycophant and an ass kisser his entire life. That's how he got his job. He was a mid-level law graduate from the University of Virginia. He hustled that into becoming an administrative assistant to Supreme Court Justice Berger, which he then hustled into getting a clerkship with Scalia, and then got a clerkship when Scalia was at the appellate level, and then he got a clerkship with Berger after that. Became part of the whole Bush Republican political camp. When people complain about Trump's personnel, almost all of Reagan's personnel were picked by Poppy Bush. There are almost no populist conservatives that Reagan picked. So Reagan had the same mistake. And then he became part of the Bill Barr regime at the Justice Department under Poppy Bush when Poppy Bush was president. Parlayed all of that into a Fourth Circuit Court of Appeals place, where while he was there on behalf of George W. Bush, he issued one of the most morally, legally, constitutionally offensive and horrendous decisions in American history, when he said that all the president has to do is call you an enemy combatant, and he can arrest you on even if you're an American citizen, he can arrest you on American soil for only doing something in America that's not a conflict zone, and he can never give you counsel, he can never give you a hearing, he can never give you a trial, he can imprison you and even torture you, as John Yoo helped advise them to do, a buddy of Michael Luttig, and there's no consequence. That's an exception to all your constitutional rights and remedies. The man who wrote that opinion, Judge Luttig. And I had conservatives tell me, what a great constitutional judge. So Luttig, who was a never-Trumper, if anybody knew behind the scenes, was the guy that Mike Pence relied upon for saying it's utterly insane to suggest that the vice president has any role at all in elector certification, even though the Electors Count Act, reflecting the Constitution and the history of it, explicitly and expressly seemed to say so, because they changed the law after the 2020 election to rewrite it to say the vice president no longer has power that the first law admitted he did have.
Can we specify that it was to remedy an ambiguity in the 1867
the 1876 statute? And the thing with this is the statute's subject to the Constitution. It's only as good as it enforces the Constitution. The power of the vice president to decide electoral contests comes from the Constitution. That's where it comes. The Electoral Count Act can't change that. So I don't think the new Electoral Count Act can change. I think it's unconstitutional to the degree it tries to take that away. And who exercised that power? I've yet to hear anybody on that side ever address this. Luttig sure doesn't, because he's a fake, phony, and fraud, like so many corporate whores that are Federalist Society folks. Is that John Adams said that power existed, and he exercised it. Thomas Jefferson said that power existed, and he exercised it. Alexander Hamilton said that power existed, and he argued for its exercise at the time of the founding of our country. Yet, according to Michael Luttig, there's no history whatsoever to support this. It's all false and fake and fraudulent, etc. And he's out there right now with Lawrence Tribe trying to claim that we can just interfere in the election wholesale, don't let the American people vote, take Trump off the ballot by saying he's not qualified under the 14th Amendment. So that's how all the Federalist Societies, the shipwreck crew crowd, all those people out there that have been apologizing for these corporate whores, for these prosecutorial, subservient, corrupt statist apologist Federalist Society frauds who don't care one iota about the Constitution and never did. They just tricked and suckered conservatives into thinking they did, can just start issuing their apologies for ever defending Luttig, because now Luttig's proven that his advice to Mike Pence was always bogus. It was part of an ongoing conspiracy to deny President Trump a fair and honest count in the election. And by Luttig's own definition, they should put Luttig in federal prison, because apparently he thinks those strategies are now criminal. And what Luttig did was fraud, and he knew it was fraud. And for him to go out there and make a preposterous, legally ludicrous claim that the 14th Amendment could keep Trump off the ballot is absurd. By the way, the reason why Luttig, once he realized he wasn't going to get on the Supreme Court, he, being the corporate whore he naturally was, he cashed in and went to Boeing and ended up getting paid millions of dollars. Because that's who these people are. He got to his position by being a sycophant, a butt kisser, from administrative assistant Then he became a gatekeeper for clerks, where if you wanted a position with a conservative corporate firm or on the court, you had to go clerk for Luttig. And then Luttig leveraged that power to when he couldn't get it on the U.S. Supreme Court, because even ordinary conservatives were like, maybe that decision saying you can call someone an enemy combatant and thereby eviscerate all their constitutional rights is a little excessive. That was a decision that couldn't get him on there. He cashed in like the corporate whore he is. Then he lied to Mike Pence, lied to the world on behalf of Mike Pence, conspired with Mike Pence to deprive and deny Trump Act a fair and honest election. And now he's going around trying to do it again in 2024, working with Lawrence Tribe in order to justify and rationalize the deep state coup that is part of the same deep state apparatus he's always been a part of.
Robert?
But when people ask me why I think Robert Kennedy is better than a generic Republican in appointing judges, no better example than Michael Luttig is one of your so-called Federalist Society heroes. This guy is a disgrace to the bench and a disgrace to the rule of law.
I've never heard of Luttig until you mention it. Is there any hush-hush behind the murder of his father?
No, only that some people speculated it showed he became very harsh and vindictive, even more so on certain criminal defendants' rights. But he's very close with Roberts. That gives you an idea of who he is. Luttig, I'm sure, was key to working behind the scenes to making sure the Supreme Court did not take the election contest case. And it's not a coincidence he's out there advising right now, keep Trump off the ballot. He said the MAGA movement is a clear and present danger to the United States. Remember, this is a guy who used the same logic to say you could be locked up interminably with no right to a hearing or trial or counsel on similar grounds. That gives you an idea for how dangerous he is.
Stefanog with a lot of G's, $100, says, can we win 2024? Can we beat the rigging, the fortification this time? Robert, can it happen?
We just have to be proactive. And they're not trying to indict Trump in all these cases unless he's the only person they're afraid of winning in an honest ballot. So that this is their new dishonest method of trying to influence the 2024 election, is these bogus indictments. And briefly on the 14th Amendment issue, as to how Luttig's argument is absurd, is ludicrous Luttig, is, first of all, the 14th Amendment doesn't even apply to the president, if you read the plain terms of it, in terms of that aspect concerning disqualification issues over insurrection. Secondly, it doesn't relate to ballot access. It relates to holding office. So it'd be subject to that remedy, not a remedy of excluding him from the ballot in the first place. Third, it's Congress who has the remedial enforcement power, and the courts have gone back and forth on whether they have it. They don't. That's there's a reason why Congress was given the exclusive means of enforcing it. And you want no better historical example of this, which Luttig ignores and Tribe ignores? Eugene V. Debs was actually charged with federal sedition, actually convicted of federal sedition, actually in prison for federal sedition, and he was on every ballot he sought to be for president,
Robert,
in 1920.
People say he didn't win, Robert. So what consolation?
Well, he didn't win, but he had the right to be on the ballot. What Luttig is saying is Trump should be stripped off the ballot. Don't allow people to vote for him. That's what Luttig is out there saying right now. And remember, folks, this is who the Federalist Society and the Bush camp wanted to put on the Supreme Court of the United States.